Have you here testifying on behalf of yourself against this bill, is that correct?
Yes, Chairman.
Okay, you can proceed with your testimony.
Good morning, Chairman Leach and committee members. My name is Bryan Blevins. I'm an attorney. I'm testifying here by myself, and I'm in opposition to the bill. I'm a practicing attorney here in Texas for over 30 years, and in the last half of my practice, I've had the opportunity to represent hundreds of small businesses, particularly in the Southeast Texas area. I've represented doctors and hospitals against the insurance industry to get them paid promptly. Mineral owners and trusts that own minerals against operators who've underpaid them in royalty payments. And then small business owners who are fighting to get payments for property damage and business interruption insurance and just general contract claims. So I wouldn't consider myself to be an expert in business transaction law or complex business litigation as this bill is attempting to address. But unfortunately, all of those cases that I just described could find their way into this very business court bill. And it's based on the dollar amounts. In all those litigations, there are smaller claims and there are larger claims. And if those larger claims are involving a commercial transaction of $10 million or more, then they're going to find their way into this court. And they're going to be split. And so now we're going to have one set of justices handling the haves, and we'll have our main justices handling the have-nots. And that's why, honestly, this is not a bill, with due respect to the testimony earlier, about all Texans. It only benefits the few. And when I talked to my clients about this bill, the concerns that they raised with me was, this is, why is the banker or the financial institution entitled to a different level of justice than the local hardware store owner or the independent rancher? Why is a bigger company, a bigger claim, a lawyer who practices on those bigger cases, why are they entitled to special judges and special courts and special rules and procedures and the new law and advanced technology and additional resources? I mean, why don't we provide those resources, if that's what's needed, in order for all Texans to have justice, the same level of justice? And why don't we provide those resources to all of our judges? The other concern that they raised is an issue that I think you can almost hear here. To my left, these gentlemen are going to be practicing in these 7 judges every day, representing these large businesses that are going to be in that court every day. I may only represent 1 or 2 cases in 2 or 3 years that is in front of these 7 judges with their own rules and their own laws. So who has the advantage? And that's the concern that they raised to me is that under a business court, is that larger claim, that bigger lawyer, the lawyers that they're practicing, are they going to have an ongoing advantage over the smaller and the individual? Beyond that, there are many concerns procedurally that Chairman Murr has been kind enough to speak with us about and has continued to work with us on. But there are significant constitutional and procedural flaws that could result in substantial delays to those cases.
Thank you. Members' questions. Vice Chair Johnson.
Hello. So to give you an opportunity, what do you perceive are the constitutional flaws of this bill?
So it is clear that the legislature does have the opportunity to create both constitutional district courts and statutory courts. However, the law looks at, well, what are you doing when the legislature passes such a bill? Just the fact that you call it a business court doesn't make it a specialty court. You look at the bill itself, you look at the legislation, and you look at how many times this bill grants that court the powers and the ability and the jurisdiction of a district court. And so, therefore, it is a constitutional district court, and therefore it must comply with the Constitution. And since our very days as a republic, our first Constitution, we provided for a divided court system with divided districts. And this creates a statewide district court where those judges are not elected, do not sit in their county seat, do not have their proceedings in a county seat, and are not elected by the persons of that county and district. Those are all constitutional requirements of a district court, and you can call this a business court or the business court of special people, or however you want to call it. It is still going to be found to be a constitutional district court, and you have to comply with the Constitution. You can do exactly, Representative Davis, exactly what you're talking about doing. You absolutely can do it. You do it through a constitutional amendment. And this body knows that and did that just last session when you increased the experience level that a judge had to have to run. So we know how to do it, but for some reason, this bill that has been coming up session over session avoids that process and seeks to establish an appointment process. An appointment process, honestly, that is inherently different than the ones you've heard about from Delaware or other jurisdictions.
Let me just go back and ask you a couple of questions, because in this bill, to your point, it says it references the qualifications, the recusal, the provisions are the same as a district judge, the removal is same as a district judge, district judge, district judge, district judge. The compensation is the same as a district judge. The jurisdiction is the same as a district judge. We go on and on about the district judges, except we have a little pesky detail known as the Constitution of Texas that says each district judge shall be elected by the qualified voters in a general election. And so that is one of the fundamental problems with this bill is we're calling it a district judge. We're giving it but we're just going to put some lipstick on it and call it something else to try to meet some sort of perceived constitutional exception around Texas's long-standing principles of election of judges.
And that's my client's concern is that they participate in their local elections. They know their judges. They know their judges know their community. And when they file their case and they get removed to a business court and get assigned a judge, not in Jefferson County, but in Wichita or Lubbock or any one of the other 7 places where these judges may sit, those judges aren't even required to have the hearings where those judges are. They can have their hearings anywhere in the state.
Well, let me ask you. So again, in our Constitution, it says that the judge needs to reside in the district during the judge's term, and it shall have hold the office again for 4 years and reside in the county where the election exists. So under this structure, the concept is the voters who get to know, work, go to school, go to church, do everything else with the people in their community can make the decisions about who they want to elect to be the arbitrators of their disputes in our civil justice system. This has been in place since 1891 in Texas and has continued to be. But under this thing, there would be only 7 judges, and the judge, from what I understand, doesn't have to live where the dispute rises, doesn't have to have chambers where the dispute rises, doesn't even have to hold the hearings where the dispute rises. And theoretically, they could decide, I'm going to be in Waco today, so you parties in Houston, we're going to have our hearing in Waco today, but next week I'm going to be in Amarillo, so you got to go meet me there. Or we're going to be in Galveston, so now you got to go meet me there, because there's no consistent application of the venue of where these proceedings are going to transpire. Is that right?
Correct. And if you could ignore the divided concept, this inherent part of our Constitution, and could have a statewide district court, then to comply with the other constitutional provisions, all the judges would have to live in Travis County. All the proceedings would have to take place in Travis County, because that's where the clerk of this court is placed here in Austin.
I want to go back to ask you about, I think some mentioning of our prior witness was about Delaware. What do you know about the Delaware structure, how their judges are appointed, and how it's different from the process as proposed in this legislation?
Well, first, Delaware has a constitution that has provided for appointed judges and non-jury trials since the 1800s.
So their voters made the decision through their constitutional process to have appointed judges, whereas our voters in Texas made the decision to have election of judges.
Absolutely correct.
Okay.
And business courts, I think they mentioned 29 in some form or fashion, have developed over the last 20 to 30 years. And all of those business courts in their various forms and fashions, no one's competing with Delaware, because Delaware already has the incorporation of over 65% of the Fortune 500 companies. No one is going to compete with Delaware because Delaware has 5 justices. They are appointed for 12 years. Therefore, they are truly independent of the appointment process. by law, the governor must appoint an equal number of Democratic and Republican candidates. Those candidates are not selected by the governor. They are selected by a bipartisan committee, and he must appoint that balanced judiciary from the list of judges that committee gives him or her.
So that process provides a dramatic distinction for how Delaware functions in its business courts from what is proposed in this legislation, right?
Correct.
And what that really does, though, is it in a lot of ways it creates the perception of the people of a fairness, because there's a balanced appointment process. There's an independent review of the people eligible to be appointed, and the term is long enough that you can have consistency throughout a set matter, and it's somewhat impervious to political influence.
Yes, and even beyond Delaware, there are only a handful of these business courts that rely upon the appointment of judges. And even a smaller number of them allow the appointee to be the governor of the state. But if you just took one example, the most recent, Georgia appoints one statewide judge to be is appointed. Now, to do that, they passed a constitutional amendment to allow that to happen.
The people let it happen. And
he's appointed, or she is appointed, for 5 years, not circulating twice through every gubernatorial period of time.
I want to go back to the structural difference between constitutional courts, statutory courts, specialty courts. Could you please discuss that, explain that to the panel, and why this is an aberration from the system that we have set up?
Well, first of all, I'm no constitutional scholar, but I'll give it my best shot. First of all, while the legislature can create statutory courts, it's never been questioned you can create more district courts, other constitutional courts, inferior courts. However, the legislature can create a statutory court. But what it can't do is the legislature may not detract, diminish, or transfer constitutional jurisdiction of the district court to the jurisdiction of another court it creates for a special purpose.
Explain that in English.
Well, if we applied it to this bill, if this business court was a specialty court, which it's not, it's a district court, as we talked about, all the different ways it relies upon its district court roots to operate. If it was a specialty court, it's a statewide one, and therefore it's not within an operating judicial district like our probate courts or certain specialty criminal courts or family courts. Those are generally all operating within the same judicial district, and they're sharing and managing and assigning caseload differentials. What this does is take a statewide umbrella and say, I'm going to take from you, and I'm going to take from you, and I'm going to take from you. Well, that's not only violative of each of those district court judges' constitutional authority, it is then also violative of my client's rights to file their case and have it pursued by the district court who has jurisdiction over that claim.
So the specialty courts, like the drug courts, those, if my understanding is correct, and Chair Moody, you may know a little bit better about this than I do. Don't they kind of have jurisdiction to a district court judge?
Yeah, and look, I've not practiced. I've had several conversations with Chairman Murr about this, and he's talked to me about probate courts in his jurisdiction, and I've never practiced in those types of specialty courts. My practice has been in district courts and county courts at law and county courts and courts of appeals. But what I do see is, number one, most of those courts still have elected judges. Most of those courts are using assignment vehicles to distribute caseloads by subject matter within a judicial district. So they're recognizing the divided nature. And they're not crossing over judicial districts and taking jurisdiction from other judges. Now, those are a few of the things that I see in those differences and which I think are problematic.
So one way, I mean, if the concept was to have a dedicated business court, we could, like, I'm from Dallas. We have a great Dallas judiciary. And I could see we could have this legislature, or could say, okay, we're going to establish a business court, a district business court in Dallas County. And that district judge, we could set the qualifications for that district judge. They have to have so many years of experience, maybe even so many years of judicial experience, or whatever the qualifications this body deems is appropriate. And then that we could give district jurisdiction to a special court, just like a family law court that we have. We have separated courts in Dallas. And that would be perfectly constitutional, right?
As far as you've explained it and I understand it, I believe the answer is yes.
Another option is we have presiding judge in large urban areas, and they could designate, in their court referral process, they could refer the cases to a specific judge that they deem has more experience in business courts, and how they refer the cases to a specific judge. We could direct that process to happen.
That's correct.
So there are other ways to achieve some of this goal that could still be constitutional and doesn't deprive the voters of their right to elect their judiciary, as been well established in our Constitution.
And what you've described has been done. I think it's the state of Michigan, for instance, passed a law in which if you have a county which has so many district courts, I think there it's 3, it would probably be more in Texas because we have bigger and more courts, but if it's more than 3 courts, then the presiding judge is to assign to one of those judges a business court docket, and the legislature define, just like Chairman Murr's bill defines, the jurisdiction that judge will hear. But the presiding judge is assigning it within the judicial district to a judge that's been elected by the Michigan voters. And the legislature could even go further and suggest or recommend the criteria that presiding judge use or rely upon when selecting the judge within that judicial district to handle those cases. There are a number of ways that a business court, if it's needed and desired, there are many ways that it could be done without poking a stick in the eye of the Constitution.
And I want you to address another line that was discussed earlier, which is the various claims and causes of action in the business court. And I'd like for you to address the point that I was bringing up initially, which is a qualified transaction is just $10 million in aggregate value with no other limitations on scope of applicability to this court. Can you share some concerns or thoughts that you have on the claim process, what's included, what's not included, what are some concerns that we would have by how it's drafted?
Well, the first thing I would point out is that only 3 of the jurisdictional areas outlined in the bill are limited to that $10 million. The others are unlimited. For instance, if you look at number 6, which is involved in action alleging that an owner or controlling person or managerial official, which are, by the way, all people, they're individuals, they're not entities, these would be persons, breached to duty by reason of the person's status as an owner, controlling person, or managerial official, including the duty of care, loyalty, or good faith. Well, we have a good faith and fair dealings duty within every contract in the state of Texas. So consequently, this is not limited to $10 million. How potentially broad could this become to sweep these cases in? With respect to an action that involved the $10 million, for instance, the question is, what do we have when we're relating to? If I have an insurance contract where I've insured my Amazon warehouse for $15 million, but I have a claim that only involves $500,000 in losses, am I subject to the business court because it's related to a contract that exceeds the $10 million jurisdiction? If there's a subrogation claim that arises out of a property damage claim, and that subrogation claim is consolidates other property damage claims that have occurred because of a hurricane or an explosion, is that subrogation claim going to be severed and shifted to a different court? Right now we have MDL Uri, which is the storm, the ice storm, and there are huge commercial transactions involved in that MDL. It's all being managed under one judge because we think the MDL process is the right way to go about consolidating for efficiency purposes. Well, if one of those parties has a business transaction that was in excess of $10 million, do they hit the removal button and go flying off to one of the 7 judges leaving the MDL process that's been put in place and worked for the last 20 years behind? I don't know those answers. Some of those have been shared. So that's just part of the concerns when you start severing. There was a question asked by Representative Slauson about a personal injury. So I'm injured by defective product. I sue the person who sold that product to me. That person, however, entered into a $15 million contract to purchase those products from the manufacturer. Well, I sue them. They sue the manufacturer. The manufacturer comes in and says, wait a minute, I'm here because of a contract for $15 million. Remove. Now my personal injury case has been dragged off to the business courts. Now, I believe that Chairman Murr's bill will allow me to then object to that supplemental jurisdiction. But what I'm not sure about is the vehicle, because under the bill, it now says that the action can be transferred or dismissed. And therefore, does that mean that because there's an improper jurisdictional claim within the action, does that mean the whole action's out? Or does that mean the whole action has to stay in because at least part of it is jurisdictionally relevant? Right.
And I guess the last point I want to talk to you about is just the process of removal. And, you know, one of the problems that I have with this bill, Chairman Murr, is that it's not mutually consented. You know, it's one thing, because we're talking about, theoretically, under the concept of this bill, sophisticated defendants with who would have a sophisticated litigation, probably all in-house lawyers within their own businesses or whatnot, and have experience outside counsel. And the fact is if there's one process where both parties could consent to have the case removed to a specialized business court, and okay, fine, if both, they're all sophisticated defendants, they can do that, or parties rather. But in this particular legislation, that's not the case, right? You can be involuntarily removed as a business. You may make that decision that you want to stay in that district court of the local jurisdiction for whatever reasons, but you can be involuntarily removed to a business court under this legislation. So.
Absolutely. Either plaintiff can make the defendant go there, the defendant can remove the case there, or now based on the committee substitute, a judge could make both parties against their will go to the business court, which I do find somewhat interesting because the Texas Judicial Council in 2022 and the Civil Justice Committee, of which Chairman Leach, I believe, was a member, actually looked at this issue of business courts and came up with 5 compelling recommendations relative to any business court. One of them was the fact that you should mutually be able to opt in. It shouldn't be able to be forced down on any party. In addition to that, they recommended a pilot project, which I think Representative Flores commented on, that we have this fully formed mechanism that's going to go out into the system untested and whatever problems it has, whereas the recommendations were, let's have a pilot, which, by the way, I think these gentlemen to my left would probably agree with me. Almost every single business court in this country started with a pilot program. That way we can learn and we can see where our problems, and we don't have to live with the unintended consequences.
Thank you so much.
The chair calls Darlene Byrne.
I just had one.
Yes, Chairman Moody.
And it's just one question. And just came up because you mentioned we're talking a lot about the system out there, but obviously that intersects with our clients as we represent them. And I just thought about my day job and the number of contracts we have with vendors. And one of the things we always have in there, make sure, is we've got our venue clause in our contract, because we want to make sure that we are in the state court in El Paso County or in the federal court in the Western District. How would that intersect here? If we're what happens to our venue clause provision?
Absolutely. And it's also one I see commonly in oil and gas leases and other documents. Chairman Murr, in the committee substitute, addressed that relative to the filing of the case and the trial of the case. So it will respect that agreed venue clause for those purposes. However, what I don't see it doing is I still believe what it does allow is you'll go to the business court, you'll still be conducted because no forum selection clause necessarily points out a particular judge or a particular district court, because we can't do that. We're going to file it in this county, and it's going to go to whichever district court it goes to. So under this bill, you're still going to get transferred to one of the 7 business district judges wherever they choose to hold their proceedings. And you're only going to be guaranteed going back to your forum selection agreement if you go to trial. And so therefore, all the important decisions on discovery, and if it's a bench trial or declaratory, injunctive relief, temporary restraining orders, all of that's going to be done by the business judge, not the forum selected jurisdiction.
Okay, I appreciate that, and obviously with the federal court it doesn't matter. But is a substitute, Mr. Murr? Is it one of them's going to be in El Paso County? Is that right? Is that what you have in there? Going to be from. I mean, I know there can be up to 2 from El Paso County. I'm not asking for that, but
Okay, the chair calls Darlene Byrne, Justice Byrne.